Threatening consumers is prohibited by the Fair Debt Collection Practices Act. Brought to you by Kenneth Chabert at yourlegalagot.com. Your advantage if you're being sued by debt collectors. The Fair Debt Collection Practices Act, FDCPA, makes many forms of threats illegal for debt collectors to make. Some of these are obvious, and some are a little more subtle. One of the obvious ones is that threats of violence are prohibited by the FDCPA. Debt collectors may not use violence or the threat of violence towards a consumer or any other person in the collection of a debt. And this includes violence or harm to property. That's Section 15 U.S.C. Section 1692D, subsection A1, which might come up in, say, repossession or foreclosure type situations, among other ways. Of course, these types of threats can also be criminal violations or illegal under other laws, but the FDCPA makes it easier to show. It has a lower burden of what you must prove to establish liability, and it includes a right to attorney's fees if you win, which a lot of the other laws don't have. You don't have to prove that the debt collector intended anything, not even that it intended you to believe or worry about anything. The action is enough. So that's great, but on the other hand, the penalties are lower. Luckily, you can combine remedies. This combination of circumstances, easier burden of proof, right to attorney's fees, and lower penalties would generally mean that you would allege both the violations of the FDCPA and other laws too. FDCPA claims do not preempt other claims. They are in addition. Certain kinds of threats are more particularly prohibited by the FDCPA. So some kinds of threats are pretty much only illegal in the debt collection context because they amount to a form of harassment. The FDCPA makes it illegal, for example, for a debt collector to threaten to take any kind of action they aren't legally empowered to take, or that they don't intend to do. And that's 15 U.S.C. Section 1692E, subsection 5. This includes the threat of filing a lawsuit by someone who can't do so, or who can't cause it to be done. And it also includes the threat of filing a lawsuit by someone who has no intention of doing so. So, for example, if a debt collector threatens you with a lawsuit, but then sells the debt to someone else instead, and this happens quite often, this very well might give rise to a claim against it. Collectors may not threaten to sell the debt elsewhere and imply that doing so would deprive the consumer of any of their rights or remedies. And here's a biggie. One thing I frequently hear from consumers is a fear that non-payment is some sort of a crime and that they'll be reported to the police. Owing money and not paying is not a crime, except in certain very limited circumstances. For a debt collector to suggest that it is, or to threaten to report or otherwise act in a way to disgrace the consumer, violates the FDCPA, and that's Section 15 U.S.C., Section 1692E, subsection 7. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegalagot.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it on YouTube, subscribe and friend me on YouTube, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.